Thank you very much. The next speech is in charge of our colleague of the Leiden University, the Netherlands.
5 minutes, no problem. I will be back in 5 minutes.
He is going to speak. His speak is about Endowed. He's Endowed Professor of Technology and Telecommunications in Law in the Leiden University, and the speech is Reconciling Big Data Analytics Contracts with Digital Platforms Regulation. Thank you very much.
So actually, the speech from Marco and from Pedro just now are actually introductions to what I would like to do with you in the next minutes that are left, which is actually taking a bottom-up approach to big data analytics and how it is actually applied in practice, and what would be private remedies against big data analytics contracts. And it's funny to remember this morning we saw a movie that Mark presented for people who were trying to get coffee. And in order to get coffee, they had to give their personal data to the coffee vendor. And I don't know if you know what the outcome was of that film. What was the dramatic ending of that film? Does anybody remember? They didn't get coffee unless they gave their personal data. So to some extent, it's also an access issue to services or products to give your data. Now, I know that you probably don't have, you're quite young enough, so you probably don't have big children yet. But I know that all my students, when I talk to them about the issue of data sharing on a digital platform, they don't give a hoot, right? Nobody gives a hoot because you have not done anything wrong. Yet when the GDPR became applicable on the 25th of May, there were some researchers, and they actually checked a profile of a blogger, a fashion blogger, a woman, who had been on Facebook since 2012. And it was very easy to get a dump of all the personal data that had been assembled by Facebook. But do you have any idea how much data they found over the 6 years about her? More than 22 million. And I've just calculated that's more than 7,500 data per day. I mean, you can hardly imagine that. And you really have to ask yourself the question whether under the GDPR, if that's maybe an excessive use of personal data or not. But that brings me sort of to my point of view, which is turning the competition laws perspective upside down, because we also know that in addition to what was just mentioned by you, that Versteger is also reconsidering the essential facilities doctrine to bring in data into the fore there. That's one of her projects as well, and not only imposing fines when there is an abuse of a dominant position in a digital platform. And there was also a point made by the moderator that the alternative to competition law may not be market regulation or the sector-specific regulation, because the time to implement such regulation is probably, in terms of technology developments, is not very useful, because by the time it's implemented, the technology has moved on, hasn't it? So I have in the next 20 minutes, I have 3 topics that I want to deal with, which are in my paper, and to some extent, it's still work in progress, true, so any comments are welcome, and then 3 positions that I'm just going to put in front of you that we can have a vote on, and then, because I thought I'm in the graveyard slot, so I have to keep you awake, so just, raise your hands, and you have some exercise there as well. Here we go. It was mentioned this morning, everything that's on your phone belongs to you. That is great language. It has no legal meaning. So one of the things I will discuss is also how do we qualify data, be them personal data or non-personal data. The other point is, of course, from big data to humongous data, we will always treat you fairly. One of the concerns that the Commission has expressed in its communication on artificial intelligence of 25 April of this year is that they want to set up all kinds of fora and groups that are going to analyze the societal impact of the use of artificial intelligence. Because so far, in fact, the model may not care that there are 20 million data of her that are floating on Facebook, but maybe she posted a message to one of her friends saying that she didn't get a mortgage loan from the bank for some reason. She was still young and everything, and maybe 10 years later that is used in an AI process when she does another mortgage request and her mortgage is refused because those data are there forever. Technology may change, but people are very hesitant to delete or destroy data. You never know. I mean, think about yourself. How often do you clean your mailbox? Do you do that all the time? Do you have a tool for that? or do you just keep everything for years? An interesting question, and it does make legal questions. So when I drafted my paper, I came up with the following model. First, I look who are actually the players in this market, because we're very much approaching it from the perspective of the competition agency and the regulator. But let's not forget who the stakeholders are. And maybe the source for big data analysis is the user of either personal or non-personal data that are provided for the purpose of data analytics. In many situations, this goes through a platform service provider, a digital platform. It can be anything. I mean, telcos nowadays have special digital platforms, and they want to know everything about you. You're not only your data use or deep packet inspection, but also your travel needs. So, and I'm giving you a lot of examples that are more like consumer-oriented. But again, one of the purposes of competition law is also enhancing the consumer's interests. And it makes a great example, but I think it applies to businesses as well. Well, it goes from the platform service provider to the data analytics company. And the data analytics company, in principle, can just process the data and distribute it to any third party. And this is where I get cynical. Provided they have a data policy or a privacy statement posted somewhere. And I did take the time to go over all Facebook's data policies, even though I had almost to go to a psychiatrist after I finished reading it, or to a hospital. I think I found about 35 without too much trouble on the Facebook site, and they're kind of hidden, but you can find them. And it says absolutely nothing. There is no transparency on what will happen with personal data of a platform user in terms of big data analytics by a third person. There's a very generic statement saying, in order to enhance your user experience and to give you targeted advertising, we sometimes use third parties to analyze the data that we have on you. They don't say how many data there are, and they don't say what all the overspill is and overkill is of those data, and they don't say what actually happens in practice. And we know from a fact, I mean, the investigation is ongoing, but I'm being a bit critical here, but we know for a fact that probably things didn't go that well with Cambridge Analytics, and the data went elsewhere and led to all kinds of push messages to users on digital platforms. So that creates also a societal question. So basically it's about transparency, and I think transparency is lacking. And if transparency is lacking, that has really adverse effects for trust. And if there is no trust and if there's no control, then you really have an issue there, I think, which cannot be solved just by applying competition law, which is not something you can solve. Even though competition law would be there in the background, you cannot solve it by saying, okay, how are we going to enforce this? How are we going to enforce these data breaches? Currently, it's penalties. So that brings me to my second point. It is regulatory law currently. It's really not about a user or a company enforcing its rights, because those rights are fairly unclear. They are based on unilateral statements that are embedded in EU regulation and in national regulation. So you have to basically use a Schutznorm. You have to say, okay, it's a matter of unlawful behavior, but you don't have any contractual rights because they have not been agreed. They are general terms and conditions. So one of the points that was made this morning by you, that was Marco, I think, was that you can also approach it from an unfair contract terms perspective in light of, so that's something I want to talk to you about, But again, on my left side, the terms are in principle now non-negotiable. So moving to the right side, it's all about giving control to the party who actually provided the data, and then I'm still not even talking about who can say that they actually own the data, because that's one thing. So these are the three questions I'm going to skim through with you quickly. The dichotomy between the digital platforms regulation and the data economy policy objectives that the Commission, or actually the Union I should say, is so keen on to regulate in order to improve our competitive position in the world. And the issue of unfair contract terms versus missing contract terms. And I mean, all the data policies that you all received in the email, they're almost identical. There's nothing interesting in there. How do big data contracts fit into private law? And what room is left for private law, and in particular for freedom of contract on digital platforms? And finally, I'm going to talk about governance. So the first dilemma is really like who's regulating what and who's being regulated. So basically, once there is an establishment of the investigation that was the Google investigation that was mentioned. Once there is a feeling of a abuse of a dominant position, or in terms of merger control, there is an unfair behavior going on. That's when it goes to the competition law authorities, and we just heard that the run time to solve that is very long, and that the behavior may change in the meantime, but it doesn't necessarily create a remedy in that case. So the GDPR and the proposal on the free flow of data and the free flow of non-personal data is what it's about, are completely, let's say, from different planets. It also has to do with the fact maybe that they come from different directorate generals. But I don't know if any of you has, I think one of you is going to speak about it in the breakout session, but I don't know if you have studied the proposal on the free flow of non-personal data in the Union. You have, and it's a totally different language. It's about facilitating economic goals, and we don't need regulation for that, do we? But it's an internal market perspective rather than a competition law perspective. So that's the first one. I think there's actually a gap there. There's a disconnect. And at the same time, you just keep putting in all your personal data. So in terms of unfair contract terms, we have the unfair contract terms directive that goes back to 1993. And we have a blue list of provisions in general terms and conditions that are void or voidable, or if they're blacklisted. And that's actually a very topical issue, because consumers are assembling in consumer organizations. They're becoming more powerful. They want to enforce their rights. I was just involved in a case for a large telco, and all the customers, the consumer customers, did not agree with a change in the general terms and conditions that actually changed the whole service provision of that company, and they lost. They lost because the general terms and conditions had very generic provisions and rights for the supplier, for the telco, but not for the consumers. And the same is true, I think, for any data subject that wants to know more about his privacy rights, or personal data rights, I should say, and that is actually asking for either access to data, either correction in faulty data. I mean, that's not the right word, but okay, I'm not a native English speaker either. I'll come up with the right term, or data portability. So port their data, which is a very hard thing. Data portability apparently to effect because of the network effects. The digital platform suppliers are not too keen to be cooperative with that, and you get much less data to take with you as a user of a digital platform than has actually been assembled and controlled and processed by the platform operator. So that creates issues, in my view, that are not addressed in the GDPR, which is not about affecting that process. So you have to ask yourself, how effective are GDPR rights that are bestowed as fundamental rights on data subjects in a very fast-going technological environment that basically tells you, I'm sorry, I'm going to kick you out. I'm sorry, you're going to get a much lesser user experience unless you provide me all kinds of data about yourself. And the pop-up screens, I just have, it's very clear that happens. And that brings me to the issue of misuse of data, which is not part of the data economy policy plans, which is not discussed and which is outside the scope of currently outside the scope of competition law scrutiny. So there's, I guess it's probably a temporary regulatory gap, but nevertheless. This brings me to what I did in the paper, and I don't have time to go into much depth with that, but what I did in the paper was I thought, okay, let's go back to some of the basics. Let's go back to discussions that took place at the beginning of the century, especially in the United States, in Chicago, which was really about who owns data. And to answer the question who owns data, you first have to qualify them. Like, are they property? What are they? Is data property? Well, who thinks data is property? I mean, it can also be an opinion, right? It can be a yes, you think so? You're the only finger that was raised very sort of carefully. So probably, that it's probably maybe the other people just thought, okay, I'm not going to answer this. But in all honesty, it is, of course, an intangible thing. I mean, we had the same discussion with software a long time ago. We had a database directive in 1993, but that was focused on the party that invests in making a database, not the data that are in there, and it didn't even address that issue. And it's not a copyright issue either, because we don't have something like originality of data. So it really depends on the various civil codes in the world, whether you can say, okay, data ownership can be established because it is a right. Data is a right, or it's something you do. And what is now actual practice? Actual practice is data use agreements. It's agreeing on how data are being used with another party, and you provide them the data. But it doesn't address the question whether you own the data. It's a very practical contract law solution. So it means that Facebook, for instance, who has assembled trillions of data of its users, takes the freedom to say, okay, well, I have access to these data. I'm going to bypass the question whether I own them or not, or whether I have a duty towards the parties who provided it, but I can license or transfer or assign those data to you, third party, and maybe I can actually state something in an agreement we have about what you can do with the data that I provide to you. And that's still a black box in the investigation. We don't know. But my hunch is, having read all these policies, that they didn't really put a lot of restrictions on the use that was being made by Cambridge Analytica, but they may have asked quite a nice hefty sum of money for those data, for providing them those data, and they didn't exercise control or governance on that. So that brings me to the question, which are to some extent cynical questions. If you have to give informed consent for certain uses of data, or explicit consent when it concerns cookies or when it concerns artificial intelligence uses, what choice do you have? The only freedom you have is to walk away from the service. And that seems to be, in my view, that seems to be a harmful situation that could be regulated in digital platforms regulation, but it's not happening. Who owns what right? That's for now, that's just whatever you decide. Who owns it? And data subjects who are consumers, except if you're Mr. Schrems, who I commend for that, but data users are consumers. We're not going to, we're all lawyers here. I'm not going to bother and write Facebook a letter and saying, I just saw yesterday that you saw what shoes I bought. Can you please delete that? I don't have time for that. But if you add it up, it's like say plastic in the ocean. It's like compiling. It's getting bigger and bigger until it becomes really something that's impossible to deal with. And can I actually license my own personal data? Do I get money? Is data currency? I mean, for now, if I use most platforms, LinkedIn, it's for free. But the mails I get from them are quite worrisome. They actually tell me what kind of job I'm looking for. I don't even know on what that's based. It's scary. I cannot use it. And then finally, if there's misuse or if it leads to damage the processing of data outcome, what is the contractual liability of the digital platform provider that actually assembled and processed those data and shared them with another party? What is the contractual liability? None. It's excluded. What is the liability under the law? What is the law? The GDPR. There are some provisions in the GDPR on that. They're in my paper, but it's not really actually very promising. Okay, this one I'm going to skip in terms of time. It's a very funny little cartoon, of course. So the Schutznorm issue I've discussed too. I'm going to go over that. And here are my 3 questions for you, which I thought, you probably don't have any questions for the discussion. First of all, because I'm taking a bit of a different approach. Second, it's in the afternoon. And third, we're running out of time. So my first question, we can just vote on that, is the union, where the initiative comes from. I don't really mind in this case. It either needs to or does not need to create regulation. It could be codes of conduct. It could be soft regulation or self-regulation that fairly balances the monetary and societal value of big data output for platform operators and for the parties who do the analytics, with the data subject's right to consent with the data transfer to third parties. Because so the last part is actually the right that you have, right? You have to consent with the data transfer, but you don't really know what you're signing off for. So do we need more regulation here? Or do you feel competition law, personal data regulation is adequate? So who thinks it's adequate? So can I take from that either you really don't want to raise your arm, maybe because it's too hot in the room, or that you're all against it? And if so, why? Or in favor of it, or in favor of more regulation? So why should we have more regulation? Yes?
Yeah, I'm in favor for the simple issue that it seems that you implied also, that here we have a missing market. So the problem is that we don't price the data. We can conceptualize the data as a part of property. So in a local term, something that it's a byproduct of our labor.
Mm-hmm.
Or in civil law terms as the right to image, to
Yeah.
our image or to our name.
Yeah.
So we can assign property rights to data
Mm-hmm.
and then exchange the data. The problem is that we have a collection action problem, so we are all on Facebook, for example, and we give data, and I cannot claim a remuneration for the labor I produce. So because of this problem, we never price the data, and they
Mm-hmm.
make profits out of the missing market.
Absolutely.
So this problem cannot be resolved except if you have a across-the-board regulation.
The monetary value for us users is that you get free access, basically, in exchange of your. That was always the thinking at the beginning of the century. I think that's really like rotten now. That's something that's been passed by. That's one thing. And the second thing about what you said on data as currency and how it works in practice is that, again, I mean, it's now functioning, I think, as a barrier to access. It's creating a harmful situation. But if you want to regulate it, then we have the issue that, in my view, EU harmonization, so internal market harmonization, is rather dead. We don't have enough agreement at the political level in the union anymore to say we have to harmonize our laws more. Our private law, there have been 3 initiatives that all died. The private law regulation at the EU level is now about functionalism. So this is exactly what the Commission does. They take topics and they take maybe problems and they regulate it in a very narrow way. But in my view, there should be a bigger view on that. There should be a discussion on the question. There should have been one in the GDPR context saying, well, what are we going to do about data ownership? If we don't give it to the people or to companies, then it's very difficult to enforce. The next one would be the data economy is or is not served with rethinking the possibility of establishing that. So that's actually what I said, and I gave you my answer. Is anybody against that? Do you think it should be part of the digital market single market strategy to say, okay, we have to think about data ownership? They can probably add something. They already have 29 proposals lying there. It's never too late, I would say.
I have a comment.
Yeah.
It's actually related a little bit more with the previous question, but maybe you
Yeah.
can connect. Maybe if we address the problem of data ownership in the proposal for a directive of digital content,
Yeah.
maybe because in that proposal they think about data as a counter performance. They don't talk about currency or something like that, but at least they are trying to solve the imbalancing powers
Yeah.
that users have with companies. Because, for example, Facebook tells you, okay, Facebook is free and will always be like that, but it's not the case because you're at the end paying with your data.
Yeah.
So maybe if we address those issues in the proposal of the directive for digital content, maybe we don't need more regulation.
Yeah. I went over that directive for this presentation too. It's still a proposal, but what I really found interesting is that proposal is very much focused on 2 very important main objectives: transparency for digital content transfer and fairness. So it would fall under the fairness option probably, but from what I read in the considerations and the explanatory memorandum and the impact analysis, it's really, the Commission is not really focusing on the issue of digital content is obviously data nowadays, as well as software and all kinds of content, but they didn't really focus about what I should say, it's a bit soft for me to say that, but empowerment of the party who is actually providing, in this case, personal data to get access to the digital content. Yes.
So in order to understand the way that you pose the questions, especially the first that I find a little bit open-ended, how do you define data in this context, and especially how do you quantify them? Because you mentioned, you gave numbers in the beginning. So if we're talking, for example, about images, already there's a way to think of intellectual property. To assign a certain value. If we're talking about posts, there is, again, appropriate.
Yeah.
What exactly do you define as data, and how do you quantify?
Yeah, it's a perfect question. First, I'm going to answer it quickly, so but first of all, in fact, the starting point is what form do data take? It can be images, it can be words. it can be music, it can be anything, can qualify as data nowadays. We do have the software directive that actually is very specific on what software is, and on the the material, the preparatory materials are part of the software and of the copyright discussion. But the point I'm making today is actually I'm really taking it from a perspective of personal data. Now, personal data can be images, but they're usually photos from that your parents or your sister took from your children. So there's no real copyright or ownership discussion there under copyright law, necessarily. It can be neighboring rights, but that's hard, right? So basically the whole personal and there's also, in a way, I mean, to some extent it works against my own argument, but a lot of the data are just useless that are being assembled. So it's just creating the plastic ocean. Exactly. There is no qualification. It's very easy for anybody just to qualify them to say whether it's an intellectual property issue, right issue or not.
Yeah. So for me, I think that in order to answer the question with regard to whether there's a need for more regulation or if competition or IP for that matter already covers it, we need to differentiate.
It's an intangible good. So that's one thing. So we qualify it as an intangible good.
Which brings us to IP.
Which brings us to some extent to IP, but a lot of the data do not qualify for any type of intellectual property protection. Probably, I don't know what the percentages. I actually was interested in empirical analysis on that. Haven't found an article yet. But so therefore, I'm taking very much an agnostic approach, and I'm saying, well, it's also, you have tangible and intangible property. It's probably not tangible. It's probably very likely to be intangible since it's digitized. So basically, what we should see is whether national civil codes have an option to put a label on them and say it's a property right. And the truth is that in the continental systems, it's a closed system, as you know, of property rights. So it's very difficult to do that. You really need to rethink. And this is something that the Commission cannot, it doesn't have the competence to do that, doesn't have the time to do that, and it's not interested in doing that because you're not going to do that for 28 or 27 member states. You will never get an agreement on that. So I suppose some member states would have to take the lead on that. And again, the literature came mostly from the United States and actually also from a few of my colleagues in the Netherlands who are actually saying, how do you qualify data as a property? Basically by just writing it in the law.
So I think the work of Jason Suits, for example, mostly talking about ownership, the shifting from property to ownership, I guess. But I just think that it's very difficult to discuss this on the basis of EU law only, because when you're talking about Facebook, this is a global company. So
absolutely, yeah. So in one country they will have issues with that, right? I mean, all the global companies will have issues with that because they don't want this. They don't want this type of problem. They already have enough problems with harmonization of law and their exclusion of liability clauses that are different for every member state or every country in the world, probably. So I'm going to go to my final question, which is about processing of data. So the processing of data for big data analytical purposes. So that's the purpose. Here's a purpose for the processing, okay? It should or it should not be regulated in digital platforms regulation alone, but it should also be regulated in the unfair contract terms directive. So maybe the unfair contract term directive is up for some maintenance. Maybe we should reopen that. We should look at it. This is my, let's say, my deep throat, my entrance to private law at the EU level, and say, okay, maybe we should look at that directive, and maybe we should come with, of course, basically any good legislator will formulate high-level principles and high-level norms, because otherwise it becomes very difficult to enforce the law. So therefore we have the fairness, transparency, equality, all kinds of principles embedded that are embedded in the treaty and also in very many EU regulations. But in terms of the DSM regulation, when you read it properly, all those proposals and some of them that have been enacted already, it's a bit boring. It's very sort of generic, and it seems very like in your face, very like low-hanging fruit, contrary to competition law. It's like, okay, so we have this geo-blocking regulation, which is all about fairness and about being able to take your content with you and use it abroad. But there are 10 exclusions to it, and it's really difficult to see how you would enforce it against what is called in that regulation a trader. Whether you're going to enforce that right? So I think that's why I have this question for you. Is it not better to take it to a higher level and to bring it under consumer rights directives? But that, of course, creates a regulatory gap in terms of non-personal data or company data. Because we had the Trade Secrets Directive. Everybody's struggling with how you bring company data under the Trade Secrets Directive. There's a mismatch there as well. And I think those mismatches in market regulation, DSM regulation right now, I think they're not stopping economic development, although the Commission is always saying that in all their impact analysis. But it's not a good thing necessarily in the long run for building trust in the European society. And the Americans, they don't care. Chinese, they don't care. But we have a different perspective in the European Union. Maybe this sounds dramatic and very, very easy, but I think that's really the case. So anybody else on this one? I guess I'll move to the last one, and I stayed within my time. And maybe if you have any questions. Otherwise, we even have a 5-minute break. Wouldn't that be great?
Are you finished?
I am finished, yes.
No,
I'm Dutch, not
No,
finished,
it's-
but
no,
I am
no.
finished, yes.
No, it's because, as you know, we have direct the debate, and probably we can continue the debate, or you like to continue the presentation?
I'm here for the audience, so it's, I have no
Yes.
desires.
First of all, thank you for a very interesting explanation. My question is, do you think it would be positive or even possible to just consider social media users as consumers and apply the Unfair Contract Terms Directive? So without the need to enact a new regulation and modify the existing directive. I mean, to the extent of my knowledge, the Commission doesn't really want to address that issue, but has moved Facebook, Twitter, and Google Plus into the direction of self-regulation. But I just wanted to know your opinion on pushing the boundaries of the law as it is.
It's an excellent idea. I'm not sure, I don't think it will get political funding or agreement in the union, but it would be a great idea to do that, to bring private law into the, and my papers, I think 60% of my paper is about contract law enforcement and governance. For me, maybe I'm too cynical, maybe because I'm much older than you, but all the regulation I see outside of unfair contract terms, in terms of data, non-personal data, it's all very, nobody's going to go after it and enforce it. There's like 1 or 2 people in the world who are interested in it, and it's just, I think it's a scary thing, the incredible amount of data that are being processed and assembled and transferred. And we live now in a time of peace. We are not in Iran, but think about if we were in Iran, or if we ever become a country like that.
I had in mind that French conflict of law case where the Paris Court of Appeal found that a Facebook user was a consumer for the purposes of, I can't remember if it was the French Consumer Code or the Brussels regulation. But so do you see the merits in taking that reasoning into consumer protection law, or do you have any faith in private enforcement?
I think it would have to be tested before the court. I mean, clearly one of the things that I had in the back of my mind also today is that the whole competition law enforcement, which is a different directorate than the Internal Market Directive, they don't seem to talk to each other. Still, after all everybody's always saying that on every conference. I did not make it up myself, but it's certainly something that I see all the time. Yeah.
Well, one question, and after I have one reflection to your questions, please.
Just a small clarification. I would like to understand if we adopt this third approach that you are mentioning, and we try to get, I guess, more transparency in the terms of service with regard to big data analytics. How would you require then the data analytic or the platform that give the data to third parties for analytics? How would you require them to specify such uses, given the nature of big data that is all about getting the data, trying to find correlation, and then coming out with new ideas and uses? How would it be possible to specify that ex ante?
Yeah, very good question. It's but the intermediary in this, it would be the digital platform providers here, the traders, the intermediary. They would be under an obligation to do an investigation of what the purpose is. and what the goods are. And what I actually mentioned in my paper, they should have an agreement which is akin to an NDA, a non-disclosure agreement. That should be forced, maybe, because they don't. I don't know if they did it voluntarily. I really tried to find out, but they should have an agreement with the analytics provider stating you're going to use purpose. You're going to have a certain purpose, and the purpose will be difficult to define, but it can be fairly broad. I mean, in my private practice as a lawyer, I have a lot of medical big data analytics projects now, but you can actually specify whether it's for cancer or for lung disease or heart disease. And then you can, and in the data transfer agreement, because that's what it would be with an NDA, you could, of course, ask from the platform provider, from the intermediary, to prohibit the party who's doing the analytics, and based on a contractual penalty, to use it for other purposes, even though the scope may be generic or broad or too narrow, and just prevent them from doing what happened in Cambridge Analytica, because for some reason, my gut feeling tells me they received some money, they threw the data at them, and they signed a standard NDA. But I do agree with you that the qualification may be challenging of the project itself.
Really thankful for your questions, and I would like to comment to you, because they are linked, the 3 questions about more regulation or not. And I think that one of the strong principles of the regulation is not new, but is stronger today, is the minimization of the data. And I think in the future, probably in the next 10 years, the courts, maybe the agencies, the new committee, probably the interpretation they will make about minimization and the service that the companies are giving. Because normally we gave our consent, but they have a lot of data that are not linked with the service. Probably in the near future, it will be some decisions, I don't know, that they say, well, minimization, you can, even you have the consent, you can manage this amount of data that is not linked with the service. Probably it could happen in the near future. But I would like to make a point. In the literature, I think they don't have paid too much attention, because in the first version of the regulation, there were, I think it was more 60 or 70 remissions to the regulation by the Commission, or delegate acts by the Commission. And in the last version, it disappeared, and today there are more or less 60, 70 callings for the next regulation of the states. And I think it has been very, very important, because if today the Commission have to make regulations, it could be very technical but very important, and it would be one regulation. And the states, normally, they don't like to regulate because for dumping purposes, because there is, like Ireland and other countries, no one likes to put more barriers to the companies. And probably it has been, for me, it's an opinion, and maybe I don't know what you think about, that this strategy in the last version to give the power to the states the result is the weakness for the consumers and citizens' rights in the data protection, because probably no one will regulate clearly that things or these possibilities of regulations. Thanks.
Yeah, I think you're right. I think it's a global issue. I think that's the problem.
There was one question more.
The question, or more asking you for an opinion. One of the things I've been seeing and reading about recently is unintended consequences of GDPR in terms of competition law and actually entrenching dominant positions.
Mm-hmm.
So what I've been people saying is that, for example, the compliance costs are so high that smaller digital ad players in the market are basically giving in, and their market share is being taken over by Google and Facebook because they can guarantee that they comply with GDPR obligations, whereas the others can't. So the advertisers actually prefer to spend the money in a way that they're sure. So is it reasonable to assume that what you have here is a conflict of public interest, one in terms of competition law, the other one is in terms of privacy, and that the privacy one is actually having an unintended consequence on the competition side? And then on the same logic, I mean, to ensure competition between platforms, you would need to have a way to easily take out your data out of it.
Yeah.
The problem is with the GDPR, what is your data or the definition of your data has been restricted, so it cannot be clashing against someone else's data. So what is valuable there is not only your posts, but for example, your list of friends. But obviously you cannot take that out now because that is no longer your personal data, it's someone else's personal data. So if you take your data out of Facebook, you cannot take your list of friends, which immediately devalues the portability of the data and entrenches the value that Facebook or any other platform currently has.
Yeah, great point. Also, I was really curious about your private law remedies. But first of all, yes, the first question, totally agree with that. But secondly, this is exactly what got me going on writing this paper. I was thinking, what are the alternative solutions to deal with this? And what about asking all the friends on Facebook for consent, because then they will be compliant. They don't give a hoot. I mean, it's not about, it's easy for large companies to be compliant, and it's more difficult for smaller companies. So it will create a competitive disadvantage. But that's why I come up with a contractual solution, and that contractual solution to some extent has to be, forced upon large providers to actually, how do you say that, preempt network effects, adverse network effects, that you cannot leave the platform because you will lose your data on your friends, for instance. This is simple. You can also actually translate it to a business environment. I mean, NDAs, so standard wording. Nobody's actually giving a lot of thought on how you should deal with non-personal data, sharing, analytics, transfer to other parties. But you can do it, and you can put a fairly hefty contractual penalty on it. And I'm just waiting for the first cases to come out. Outside the EU, that is. Yeah, thanks.